For those who don't know me, I'm Neil Thompson. I'm with the Public Prosecution Service, and I will be moderating for today's session. As usual, the matter today will be recorded, so those who need to step out or attend late will be able to access this online, and members in the future will be able to access today's recording. I want to start by thanking our two presenters. We have Eric Neufeld and Daniel Song, both counsel for the King, giving their time today quite generously. We will be able to interrupt them if we want to ask questions, or we can save our questions till the end. And I believe you can set your chat to talk to everyone or just hosts and panelists, either or. If you send it to just hosts and panelists, I will just repeat your question for presenters. So I want to start with a proper introduction to our first speaker, Mr. Eric Neufeld. He was admitted into the Law Society of Saskatchewan in 1975 and has practiced in the province ever since. After spending the better part of 10 years in private practice, primarily civil and criminal litigation, he joined the Public Prosecution Service of Saskatchewan Justice in, Public Prosecution Division of Saskatchewan Justice in 1985. He served as a Crown prosecutor and later as a senior Crown. Was Director of Economic Crime Prosecutions in Southern Saskatchewan until 1998. In 1999, after completing a secondment to the Federal Prosecution Service as counsel to the newly formed Integrated Proceeds of Crime Unit, Eric returned to Saskatchewan Justice as Director of Special Projects at the head office of Public Prosecutions, as well as doing appellate work. In 2009, he was seconded to the RCMP Proceeds of Crime Branch as a subject matter expert in the development and delivery of both online and classroom training for financial crime investigators. In December 2011, he retired from the Federal Public Service and returned to private law practice with the Findlay Law Office in Regina. The firm is the appointed standing agent of the Public Prosecution Service of Canada for the Swift Current and Estevan prosecution areas, and Eric is a member of its prosecution team handling federal prosecutions in those areas. Eric has a Bachelor of Laws in 1974, Bachelor's of Arts 1971, degrees from the University of Saskatchewan both, and he received his King's Counsel designation in 1996. So with that, Eric, thank you for being here, and I'm going to mute myself and leave it to you.
Thank you, Neil. I'm going to see if I can make the technology work and share my screen with you. I'm hopeful that everyone can see it. Can you see it, Neil? Okay, perfect.
I can, yeah.
Daniel and I are going to share the podium today, and my focus as a Crown is to consider how to deal with search warrants as a Crown and pre-trial mostly, which is why I've titled my presentation, Will It Survive? Essentially assessing a warrant to determine what impact it may or may not have on the case. I have to present this slide, which means I speak for no one. You can rely on nothing that I say, and this is all for training purposes. But I want to make sure that nobody relies on this stuff necessarily for case-specific advice. Again, as I said, the focus of my presentation is in assessing the warrant and its underlying foundation, which is, of course, the ITO, the information to obtain, and try and point out what I think you need to know and how to apply that knowledge, but certainly as a Crown, and most certainly no reason why any of this doesn't apply to a defense dealing with search warrants. Again, I'm not much going to be involved in the supporting law. I'm more interested in the application, and it is from the Crown point of view, but we have a balanced presentation because I know Daniel will go into great detail with respect to the defense point of view, which is as it should be. we have to begin by remembering that the warrant, certainly from the Crown side, the warrant has an impact. And for the Crown's purposes, the presence of a warrant is a strategic advantage. If there's no warrant, there is a legal presumption that the search is unreasonable and is a charter violation. And then the burden shifts to the Crown to demonstrate that the search or seizure was actually reasonable and was charter compliant, which essentially means proving that there was either statute-based or common law authority to authorize the search or seizure, and then obviously establishing its factual background through, or factual basis through calling evidence, usually of the police officers involved. Conversely, if there is a warrant, the presumption is that the resulting search and seizure is reasonable and charter compliant, that no matter what, whether the document is a piece of trash or not, at the end of the day, the burden then shifts to the defense to attack it by proving a charter violation and persuading the court that the evidence should be excluded. So far as the Crown is concerned, that strategic advantage evaporates very quickly if the warrant is defective or the foundational document, the ITO, is deficient in some material way. And again, there's lots of cases that deal with the how you attack warrants and how warrants are assessed. But a case I like to look at is a case called Sadikoff out of the Ontario Court of Appeal. And it summarizes this whole process quite well, I think. And it is essentially tells us that when challenges are made to warrants, they can be either facial or subfacial challenges. And so that's really the two possible things that can happen, and the two possible things that, as a Crown, I look for when trying to assess these documents. Facial validity, just as a reminder, really makes the court decide whether you're dealing with the face of the document, you're dealing with the words on the page, and it's what is on that page or on those pages. Does that meet the test that the justice could have issued the warrant? It's not, again, the courts have been reminded over and over, it's not the reviewing judge's decision as to whether they would have issued the warrant or not. It's a question of could it have been issued when all of the problems and issues that are addressed in the face of the warrant, or the ITO for that matter, are assessed, and really what's left to support the issues that need to be supported. It's not a situation where we get to patch. As the court points out, it's the review is fixed on the documents themselves, and it's the ITO, essentially the foundation, and nothing more, not any amplification or enlarged record. Daniel, I'm sure will mention, or if not, I can simply tell you that there is an opportunity usually for the Crown through evidence to fix mistakes that aren't that significant, and that's called amplification. You can't really add new grounds or make the warrant better than it is, but you certainly can fix some things that in the long run probably don't matter. But in the facial validity test, we're looking at the paper and only the paper. Subfacial validity is different because now the challenge is going behind the actual words of the ITO to try and demonstrate that the content is not reliable. And often these things do involve an amplified record, but again, it doesn't permit the court to, the reviewing court, to impose its own view on whether it would have issued the warrant or not. And once it comes to a subfacial challenge, then the judge has to decide on the record before them, with some amplification in some cases, could the justice have issued the warrant? And so different considerations, different factual considerations can come into play, both from the Crown side, certainly from the Crown side, when it comes to amplification to fix things that are obviously deficient and easily fixed, but do not really make the warrant stronger in that sense. And then again, the test is for the reviewing judge to say whether there is still enough reliable information, including the amplified record, that the stuff might have been reasonably believed, and then the warrant could have been issued. So those are the two differences between facial validity and subfacial validity. I'm approaching this from my validity assessment presentation based on the focus of a pretrial prosecutor, which will be, in most cases, this is before a challenge takes place. This is early on in the assessment process, and the focus will be on facial validity because you probably don't know much else at that point. You're unlikely to become aware of subfacial issues until we get a charter notice, or we hear evidence in a charter voir dire, or sometimes we get tipped off by defense cross-examination at a preliminary, or we find something buried in the police reports and notes that might point to a problem subfacially. So the focus in this presentation is to give my view on assessing the facial validity of the warrant as it is on the paper and the facial validity of the ITO as it is. And really to decide if it's likely that if it is challenged and reviewed, the court will find that the justice could have issued the warrant based on what's left. So that's the focus of my presentation on validity assessment. The impact of your assessment as a Crown certainly is important because it will inform your approach to the prosecution. If you have a warrant that is apparently bad or weak, it's going to make an impact on your decision as to whether you have a reasonable prospect of conviction. If there's a significant risk of loss of evidence, you might not have it there. It'll also impact how you approach your pretrial resolutions, either early on or later. Is this a case where you have to give a lot in order to keep the prosecution in play? Not that you can't proceed, but it's a situation where there's high risk and your resolution position may reflect that. And it will also implicate or impact trial strategy on charter applications. Sometimes we're faced with a situation where we have to concede the violation, but will and can legitimately argue that it's not something that should be excluded under 24.2 for whatever reason. And when you do your impact assessment or your pretrial assessment, this can be the birth of your argument and your analysis for preparing a reply to what is almost inevitably a defense charter challenge. In the drug world in which I prosecute, if we catch you with the drugs or other contraband or undeniable evidence of another crime, usually the only way out is to try and get the evidence excluded. And barring real issues about possession or trafficking or for the purpose in drug cases or other elements of the actus or criminal intent in other cases, we don't see trials on the merits. They tend to be the exception rather than the rule. The trial is usually on whether the evidence was lawfully seized or not. From a starting point, my recommendation is the first question you should ask yourself is, does it matter? You need to get and look at a list of the seized property that they're usually in the police reports or seized property lists or exhibit lists. And you want to take a look and find out whether was there something seized from the accused or or some place where the accused has standing to complain. Seized, of course, means taken or examined by state agents without consent under the authority of the warrant. If there's no warrant, different considerations apply, and that's not part of this discussion. So the question you have to look at is, are any of those things needed to either prove an element of the offense or to underpin a further warrant where such necessary things were found and seized? And the classic example, of course, is perhaps a series of tracking warrants or number recorder warrants, things like that, that have ultimately led to the development of grounds which now support the execution of a warrant at a particular place to get the actual evidence that is incriminating and usable. And sometimes the risk is that that initial warrant has the big problems with it because it underpins the grounds that are in your final search warrant. And so if you need the thing to prove the charge, or if you need the thing to support a prior warrant, then it probably you want to know because it will matter. If it doesn't matter, your warrant assessment can stop at this point. For example, in the situation of mobile phone warrant results, sometimes they come up with no evidence because they couldn't get into the phone, or there was nothing in value in the extracted data. And as a rule, nobody applies to exclude evidence that doesn't matter. So you really need to first assess, do I really care? Does it really matter to the Crown's case? If it does matter, then the next thing I think you need to do is know and understand what you're going to be looking for. And the way to do that is to identify the statutory provision which authorizes the warrant. And as we remind police over and over before they write warrants, read the statutory provisions, read it front to back. Most warrant provisions don't take more than half a page in the criminal code. It doesn't take long to read them. But what it does is it helps you identify or remind you of the requirements that that had to be met to justify the issue of that particular warrant. So you want to identify what offenses does this particular provision apply to, what things or information does it apply to, what places or persons does it apply to, and also identify the standard or the level of proof that's required, as well as any other limitations which apply to whether the warrant was issuable or not, and whether it generally complies with whatever forms might be specified in that particular provision. And the necessary material, of course, is the relevant statutory section which authorizes the warrant. In most cases, you're looking at the criminal code, section 47(1), which authorizes a court to issue, the justice to issue a search warrant for evidence or other qualifying things. Evidence of a specified criminal offense, for instance, a weapon used, forensic evidence implicating the accused, and such things. In drug cases, it's often used for weapons or other things that the CDSA warrant cannot be used for unless that those things qualify as offense-related property under the CDSA. Again, it's most common in drug cases. We see 47(1) warrants for searching cell phones and getting the data extracted. There are lots of other provisions that come into play. 47.01 general warrants, 492.1 transfer things and people, transmission data warrants, and also document production under 47.014. And again, because of the way Section 47 is worded, it can apply to any offense under the criminal code or other federal statute, even those which have their own warrant provisions, which is one of the examples is the CDSA. So you often see warrants which, or maybe two warrants, maybe warrants which relate to two different offenses and refer both to the CDSA and the in Section 487, because there are certain things in some investigations that are not covered within the bounds of a CDSA warrant. The CDSA is another very common warrant we see, and certainly Section 11 is the statute provision authorizing warrants where police can seize controlled substances, precursors, offense-related property like containers, packaging, things like that as evidence, but it is limited to CDSA offenses and proceeds possession under 354 or money laundering under 462.31 that are underpinned by a CDSA offense. And when you're looking at these things, you should always draw your mind to the standard of proof, and it's almost always identified in the warrant provision by looking for the word satisfied, because that's almost in every, I believe it's in virtually every warrant provision, where it tells you that the issuing judicial authority, justice, or judge has to be satisfied to a certain standard, to a certain level of proof, and also then tells you what has to be proved to that standard. Just to put the code provision in your face, you'll see the word satisfied in 487(1). Satisfied by information on oath. There are reasonable grounds to believe that there is in a building receptacle or place certain things that qualify to be seized, and then allows the issuing judicial authority to give a peace officer the power to search and seize things and direct them to make a return to the justice. Sometimes people do get confused, and which is why I highlighted may issue a warrant authorizing a peace officer, because it goes on to talk about or a public officer and a description and the fact that they have to be named in a warrant. Sometimes people get mixed up with the peace officer and public officer. When you're dealing with peace officer, after the word peace officer, that's where you stop. Public officers are different, are in a different category, and they have to be appointed in a certain way with certain duties and actually have to have their names in the warrant. So don't get mixed up by the fact that it goes into a big discussion about people being named in warrants. Mostly we don't deal with the public officers. It happens sometimes, but not often. Then the other probably most common warrant is the CDSA search warrant. And these are the provisions of the warrant. Again, there's that word satisfied and information on oath, and there are reasonable grounds to believe certain things, which are the list of things that can be authorized to be seized. Most commonly is anything that will afford evidence, but and controlled substances. And again, in a place, and they can issue a warrant to search. And again, this is what the standard, almost always drug investigations will use to get evidence. It's useful to keep in mind that there are two proof standards that will help you try to assess whether your particular warrant or ITO is good enough. And those two standards are the two proof standards of investigative standards in the criminal code. The one is reasonable grounds to believe, which is certain things based that give the issuing justice a reasonable belief that certain things have happened and that search warrant should be issued. And then the other test, which I won't mention other than to describe it, is a lower test, which is reasonable grounds to suspect, a reasonable suspicion test. And you need to identify from the warrant provision which is it that you're dealing with, because they are different and require different levels of proof. In a search warrant and in a 47 code search warrant and a CDSA warrant, we're dealing with reasonable grounds to believe or reasonable grounds to believe or reasonable belief. Most cases we don't deal with a reasonable suspicion, but there are a number of warrants that are allowed to be based on reasonable suspicion. And just to illustrate as best I can what these tests really mean, or the standards mean, the reasonable grounds to believe have to be based on credible facts or information. And that belief by the person swearing the ITO has to be subjective belief in the sense that they believe it. And it also has to be objectively reasonable in the sense that reasonable third parties in the same position and training and whatever of that particular officer would likely come to the same conclusion. So there has to be some objective basis to say, yeah, that not only does the officer believe it, but everybody else, other reasonable people would believe it because of this, this, and this, and this. Right? So, and when you have this combination, you actually have a reasonable belief. And sometimes we try to not that successfully, but try and give people a sense of what does this mean in terms of certainty, okay? And if you were to try to plot reasonable grounds to believe on a spectrum of certainty where you have the one end where it's the purest of unfounded suspicion, the hunch, and the other is for sure, there is no doubt, it is for certain. I think you would come up with a spectrum of certainty that would look something like this, that reasonable grounds to believe does not mean even 51% in terms of certainty, and is definitely a lesser test. And again, this is my depiction of what I think it is likely where this lies. But certainly the courts have told us that reasonable grounds to believe requires more than mere suspicion, but less than the standard applicable in civil cases, which is proof on balance of probabilities. So it's clear the courts have told us, and sometimes we have to keep reminding ourselves that this is not a test that is as high as sometimes we perceive it to be. And you can also, if you ever have to deal with a reasonable grounds to suspect, you can approach it the same way. You have the credible facts information, you have subjective belief, you have objective reasonability, then you have reasonable suspicion, and probably if you plot it on that same certainty level, you're probably going to go down a bit, maybe to there. Okay, so it's a lesser test. It's not pure suspicion, but it's suspicion founded in reason based on the facts in the situation. So the next step then is to make sure that you have the relevant paper, and the necessary material, of course, is your warrant and your ITO. Strangely enough, we tend not to see the ITOs as soon as I think we should. Even if they're vetted, there's all kinds of processes that seem to be internal with some police forces in any event, where this vetting seems to take far longer than it should, the redacting. We get the warrants early, but often we don't get the ITOs early, and really the ITO should come very quickly because it's already been, the warrant's been executed, and other than knocking out information that has to be kept secret, it shouldn't be that difficult to give us those ITOs, but there seems to also be some delay. What you want, of course, is a copy of the issued warrant with the date of its issue and the signature of the judicial authority. You also want a copy of the information. That's the best case. You want the copy of the actual document. Sometimes that doesn't show up right away. Sometimes you get copies. And you want, obviously, you want the information to obtain. You want a copy of the sworn document with dates and signatures, which is what you want to be certain. And of course, you want a list of seized property from police reports or actual seized property exhibit list, which is the best thing to have. And then you should be beginning by assessing the warrant itself. So, in assessing the warrant, you need to read the warrant carefully, which goes without saying. Usually it's no more than 2 or 3 pages, and you want to look for, is it apparently in the specified form? In section 487(1), they give you a form reference called Form 5, which is in the back of the criminal code. If one were to pull a Form 5 from every province and territory, you might wonder if we live in the same country. But clearly, the criminal code provides for variations. Really, it's is the guts of the material in there to compliance with Form 5. And with CDSA, there is no specified warrant form for a CDSA warrant. But most of them are built on a derivative of the criminal code warrant, which is Form 5, but varied to suit that particular CDSA statute. Look at the document to see that it is signed and dated by a judicial authority who is actually authorized to issue it. And with the criminal code and the CDSA warrants, they can be issued by justices of the peace or provincial court judges who all fit within the code definition of justice. But there are some warrants which can only be issued by a provincial court judge, For example, DNA and general warrants. Again, for the purpose of this procedure, or this presentation, we're dealing with warrants that can be issued by a justice. So you want to be sure that it's reasonably close to the form and that it's actually been signed and dated by a judicial authority. And sometimes they're not. So you got to be careful. When you're assessing the warrant, you want to look at the content. And the question is, does it describe in an understandable way, first of all, the person who swore the supporting ITO? Does it describe the offenses that are alleged to have been committed with the proper section number? Does it describe adequately the things that can be seized under the authority of the warrant? And that's very important because sometimes, almost every time, police, when they show up to execute a warrant at a particular place, will find something that has evidentiary value but is not covered within the description. And if you look at the things that can be seized and find you've got something that doesn't fit the description, now you have to, excuse me, you have to reassess how you're going to approach those things if they're material, because you have to rely on different non-warrant authority in order to justify their seizure. Very often it's 489(2) of the code, which has to be justified based on the specified grounds by the testimony of the police. Also, you want to be sure that it describes the place that can be searched for these things, because it does happen that the warrant is too circumscribed, so that where they actually went is not actually covered in the warrant. And so you want to be sure that, apparently, at least on the face of it, they were executing the warrant at the place where they were entitled to do it. And also, when does it describe when it could be executed? Is there dates and times and those kinds of things? You'll often find that warrants are saying you can, they actually say you can execute it in the next day and a half or stuff like that. Haven't run into big problems with that, but you want to be sure that it isn't too long, because then recency comes into issue in terms of the grounds that supported the search in the first place. You want to be sure that in your ITO, the offense is one to which the provision actually applies. Is the offense one known to law? I had to deal with a situation where, fortunately, we had more than one offense, but one of the offenses described was not an offense. The police thought it was, but it wasn't under the CDSA. And so we had to deal with the argument about that. You want to be sure that the offense actually exists, which means look at it and give a check in the code, look at the offense itself. And then, are the things qualified to be seized by that particular provision? A particular thing usually is specified in a code warrant, or a thing from a limited class of things. And is the place one that the provisions allow to be searched? Check the addresses, and when it becomes a mobile phone warrant, check to make sure that they've actually named the phone and the right phone, described it. It's not unheard of to show up at a search site and find out that numbers have been transposed, and suddenly the police are at a place they're not authorized to be. And very often, unfortunately, sometimes it happens that they don't discover that until partway through the search. And so that creates all kinds of problems. So you want to make sure that they're in the right place, or we're in the right place. And also, was the search done within the permitted time parameters, which means you got to compare the police reports to what the time parameters, if any, are given in the warrant itself. If you get a bad answer to any of one of these, it could potentially spell doom for your warrant and force you to, as a Crown, to have to fall back on Section 24(2) to try to avoid exclusion of the evidence. In assessing the warrant, when it comes to 487(1) code warrants, you have to watch for the day-night issue. Okay. The criminal code, the question is, does it specify a night search? And a night search means 6 p.m. On one day to 9 a.m. on the next day. And again, it's strange to me in this day and age that these warrants inexplicably still have this day-night restriction by reason of the operation of Section 488 of the code. Other warrant provisions don't have that. CDSA warrants are not subject to such a restriction. They're just as intrusive, if not more, and so it kind of defies my logic as to why we have that day-night limitation in Section 47(1) warrants. Nevertheless, it is there. You have to be aware of it. And in order to lawfully execute a warrant during night hours, which is the 6 in the evening to 9 a.m. the next day, the warrant has to actually say so, according to Section 48, and grounds to justify that need to be in the ITO. And they have to be something real, not just, I was getting off shift and I couldn't get overtime, those kinds of things. Those aren't legitimate reasons to get a night search authorization. If you have a negative answer, this may be a failure if the warrant was executed between the night hours. They weren't authorized to be there. Again, CDSA warrants don't suffer from that limitation, but if you happen to be dealing with code and CDSA warrants at the same time, you want to be sure that both of them are executed within the code warrant within the night restriction if they're permitted, and the CDSA warrants usually are executed at the same time. And you don't want to hope that they didn't execute it when they were entitled to under the CDSA, but not entitled to under Section 47. Also watch for execution times and dates in the warrant. Typically, you'll see or should see enter the place between 2 time periods and thereafter to search. Sometimes the drafters are not careful and the wording is enter and search between these 2 times, which is fine, but you want to be certain that if the entry and search is limited to that period, which still happens sometimes, you want to make sure that the search was started and done within that time period, because if it wasn't, you again may have a problem with charter compliance. Things to look for and remember are that the wording of the offense is important. In the warrant, and practically speaking, what happens, as you probably all know, is that the police draft these warrants based on their precedents and templates, and they're presented to a justice or judge with the ITO, and if the judge has no concerns or just has no concerns, they're issued as they are drafted. But ultimately, the offense under investigation has to be written in a way that the reader will know the reasons for the search. And it's not, you don't require the precision of an indictment because you're not laying a charge. And what we find very often is the police will default to using the forms at the back of the code, not the code forms, but in a publication, for instance, like Martin's Code, they actually have what they call the brown, or what we see as the brown pages, which actually have the wording of charges as they would or could be worded if a person was charged. And you need to watch, which is fine if the circumstances back those wordings, but you need to be when you're assessing, to be certain that they haven't created an offense description which has far too many particulars that aren't supported by the ITO grounds, and that too can then cause you a problem later on. So we discourage police from using those forms of charges, as they can cause a lot of trouble. And quite frankly, I think if you simply say murder, contrary to section whatever it is now, that's good enough for a description. Again, you should always hopefully make sure that they've written the offenses identically in the warrant and the ITO. I'm not sure it's fatal if they haven't, but it could cause problems. Recently, I saw a judge actually reworded the offenses and I think the things description and the place description, which didn't match the ITO, but we take the position, well, that wasn't our fault. That was the judge who decided to do that. Again, adequate descriptions are needed for whatever things are being authorized to be seized by the warrant. Again, they have to be sufficiently precise so that the searchers can identify what they're entitled to seize under the authority of that warrant and what they're not. And that's precisely the same test that may happen when the warrant is later challenged, because the argument will be, if possible, is that whatever they seized is not something that was authorized by the description in the warrant, and they have not explained how it was that they were still authorized to be taken. So again, there are no fishing expeditions are permitted. You can't get a warrant for just looking around for stuff. And a search will be unreasonable where the description of things you're looking for is overbroad. Watch out for descriptions have to be, again, as I said, descriptions have to be good enough that on a later examination, the judge, the reviewing judge, can say, well, this fits within the authorization of the warrant and this thing doesn't. Okay, so there has to be, description has to allow that kind of assessment. It is permissible to use classes of things where the subject matter of investigation is complex, say a fraud or something of that nature where there's a lot of potential documents, but the police are not capable of identifying each and every one. So you can use class descriptions, but they have to be limited in a way so that they are not overbroad. And again, so that the reviewing authority later can actually say, this one fits, this one doesn't. Okay. Overbroad descriptions, if you ever see the word all, you begin to shudder and worry. Okay. Because you're now, the description is starting out with a potential overbreadth problem. It is possible to use that terminology, but it has to be limited or qualified in some way. So you can't just say, I want all bank statements or other financial records, because it's too broad. But there needs to be limits and a link to the ground so that, for instance, you can say all bank statements and other financial records relating to a particular transaction or a particular date range, or bank statements or records related to a particular activity, like monies coming and going from a particular individual. So again, watch for those things. Not too long ago, I saw a CDSA warrant that in one of our files that started out by listing the drugs and all of the usual things, and then ended up with the phrase, and any other evidence of the crime. Okay, that was just bad news. And so again, not necessarily fatal, depending on what you search, what you've seized, and whether it fits in the actual description or into that all other. So watch carefully for where you see things like all or any, because they are indicators of potential problems with overbreadth. Something to keep in mind, and the police probably don't use this as much as they could, but Section 2 of the Criminal Code, actually the CDSA and the Criminal Code, have the concepts of offense-related property, and actually some other statutes do as well. But as you will have seen when we displayed the 487 sub 1 provision and the Section 11 CDSA provision, one of the things that a warrant can authorize in and of itself without any authorizing anything else is offense-related property. And in the criminal code, Section 2 defines offense-related property, means property either in Canada or outside Canada, which by means of which an indictable offense under the code or this other federal statute is committed, or it can be anything that is used in any manner in connection with the commission of such an offense, or anything that is intended to be used for committing such an offense. So even if it hasn't been used, but we can demonstrate that it was probably intended to be used, then a search warrant can be issued for something offense-related property. The CDSA has an identical provision, but it's limited to offense-related property related to a designated substance offense, which is defined as an offense greater than simple possession. So sections 5 and higher in the CDSA. The code offense-related property is limited to indictable offenses under the code itself and another federal statute. So again, if the objective in the search warrant is to seize offense-related property, you want to make sure that the grounds ultimately will demonstrate that that it is in fact offense-related within the limits of one or both of those statutes. In terms of demonstrate or describing places that are to be searched, the 47 warrant provisions can allow a search of a building, receptacle, or place. So it's primarily place directed, but not the human body or even intangible things. For instance, bank accounts we deal with by proceeds of crime legislation. So really, it's focused on actually real physical things in most cases, and you want to be sure that your warrant fits within that category. You want to watch in the warrant to see that they've adequately described situations where you're dealing with multiple unit building, where there are sublocations. Sometimes the police show up and discover that what looked like a single residence is in fact several. And you want to be sure that they kept themselves circumscribed as much as they could to the implied location of where the actual suspect lived, perhaps. A problem sometimes is outbuildings and vehicles, things like sheds or detached garages, things that are on the property and are sometimes referred to in the place description. Again, you want to be sure that if it's an outbuilding or vehicle, it's actually identified as such generically, or preferably a specific vehicle that there are grounds to believe will be there. Certainly, same thing with outbuildings. Often the inheriting of descriptions between police officers can result in a standard clause of vehicles and outbuildings. And when you see that described in your warrant, you're going to want to be sure that there's some kind of grounds in your ITO to demonstrate that such things actually exist and might have or probably have evidence in them. So as soon as you see that, you're going to be wary. And again, if police can, if they don't have a street address or a rural land description, they can actually use a meets and bounds. You know, it's like from this highway to that highway to that way and to this particular place. It doesn't happen very often, but every once in a while, there are places where they have to be dealt with purely by description, which is fine. It just makes it a little more cumbersome sometimes. Something else to watch out in warrants is which places are authorized to be searched. And it is true that one warrant may authorize the search of more than one place. You often see, certainly in commercial fraud cases, where, you know, search the house, search the office, search the cottage. And it's perfectly permitted for one ITO to establish all of the grounds that are needed to search each and every place. But you want to identify in the warrant right away, do I have multiple places? And I'm now going to have to focus on the grounds in that single ITO. I might have 3 warrants, but I'm going to have to focus on the grounds in that ITO to see if the grounds are enough for each one of those places, okay? And what happens very often is that it's very easy when their focus is on the bigger picture of 2 or 3 places to come up short on grounds for one of those places. So The minute you see the search of more than one place, your antenna are going up and say, oh, okay, there's something I'm going to have to worry about later when I assess the ITO. Warrants don't authorize the search of people, persons, or occupants. There are, police will tend to freeze the scene and create all kinds of problems for charter purposes when, in fact, there's no authority on the warrant to actually detain or search a person. Sometimes it's justifiable for officer safety reasons, but again, generally it's not permitted. The CDSA does have a unique provision that it allows the search of found-ins if there are reasonable grounds to believe that they might have some CDSA material on them. A warrant can authorize the search of a vehicle. Again, it's about, was it properly described and was it even on the property? The minute you see a vehicle, your antenna again are going to go up and say, was the vehicle actually on the property or was it sitting on the street, which is quite a different situation when it comes to a search warrant. Warrants can obviously cover attached garages, but they cannot deal with detached garages unless they're specified, and the same thing with vehicles. Okay, now you've had a good look at your warrant, and you now want to assess the ITO, which is the next step, because without the grounds that you need, you're not going to have much luck in supporting a warrant. Again, you need the paper. You get a copy of the signed sworn ITO, and very often it's a vetted or redacted version. Always keep in mind that what the defense cannot see, the reviewing judge cannot use to assess the facial validity of an ITO. And so you might have to face at some point an unvetted or partially unvetted or unredacted version if that is what if it appears the ITO is insufficient. And I won't go into the details of that, but there is something called the step 6 of Garofoli, which Daniel may talk about. But there are situations where you simply have to do something about your ITO because it's been too heavily vetted to the point where the grounds on their face can't meet the facial validity test. So you want to look at your ITO right away. You want to look at what's been vetted out. You don't necessarily have to see what's underneath the black. Sometimes it's helpful to actually just take a look at it as it is and assess it. And that's usually the best way because that's the way the facial validity test is going to go. Later on, you can delve deep into the redacted parts if it becomes necessary. Again, you're initially going to assess the vetted version. Is it good enough on its own? Okay. Again, you can wait till later to look at the unvetted version. And again, unless you have serious doubt about its sufficiency of the vetted version, you will want to know whether you can fall back on judicial summaries for sufficiency if the reviewing judge happens to decide that the ITO as it is vetted or redacted does not make the grade. Again, read the authorizing statute provision carefully and read the ITO carefully. Simple things like, is it signed by the informant or affiant and signed and dated by the person who took the oath? For instance, the commissioner for oaths, the notary public, or even the justice of the peace. In our province, every police officer is a commissioner for oaths by statute. And so there's no need for the police to go to the justice to actually swear the document, but sometimes it happens. We don't like it because the risk is so high that they might answer a question or say something that doesn't appear within the 4 corners of the document. So mostly you'll see these things signed by commissioners for oath, often police officers. You want to see, is this ITO in the specified form? And in 47.1, the form specified is Form 1. And again, it also can be varied to suit the case as Section 8 or be to like effect as 849 of the code says. The CDSA does not have a specified form for their ITOs either, but as I said earlier, you're usually looking at a Form 1 derivative from the criminal code that has been, a template has been built, which addresses the CDSA as opposed to the code issues, but it's very similar. It's just a useful reminder to look at the kind of the elements of search warrants, for instance, Section 487. And this is kind of a summary of what you will dig out when you read the statutory provisions, but it talks about who can authorize it, what the level of proof is, what the offenses are, what the things that qualify to be seized are, and somehow that they are now in the place to be searched. Recency is an issue when it comes to movable things. So that's something you want to look at when you're addressing the sufficiency of an ITO. For instance, evidence that drugs were in a house 6 weeks ago is interesting, but it really doesn't go to the recency that suggests that, or that should suggest that the contraband is there now when you swear the ITO. And again, you can only authorize peace officers or public officers to enter, search, and seize places, receptacles, and buildings. And of course, there's the day-night issue that you have to keep in mind. The CDSA can be broken down the same way. Again, similar authorizing authority, information on oath, reasonable grounds to believe, the CDSA offenses that can be covered, the things that can be qualified to be seized. And again, are they now in the place to be searched? And again, the authorization is for a peace officer. Your ITO, the police ITO, has to establish that there are reasonable grounds to believe certain crimes have been committed, certain things exist that qualify to be seized, and certain places contain the things. And you can look at assessing ITOs by answering a series of questions very often. And really, you can look at the ITO and say, okay, what are the answers to these questions? Is there sourced credible information that answers these questions? First question is, what offense does the informant or affiant believe has been committed? What question or what things is the informant or affiant looking for? Where does the informant believe those things are? Why do the informant believe they're in that place? And why do the informant believe they qualify to be seized? And why does the informant believe the offense has been committed? So it's a series of what and why questions with a where mixed in. And that's really what you're looking for when you're assessing an ITO, certainly under the criminal code and under the CDSA. What do you want to see in each ground? What the police need to do, the affiants or informants need to do, is in each ground, in each paragraph, they need to describe the information that they're giving, the factual information. Sometimes they need to explain why it's important. Not always. And then how did the person come by that information, and what's the ultimate source of that information? If it's a third party or something else, then it goes beyond simply the police officer saw or did something. It's someone else saw or did something, and how is it that they know, and why should that be credible? And it's important to link all these things together as the grounds are worded and written. And just as a kind of a picture example, in a criminal code search warrant situation, the first thing the ITO has to demonstrate there's reasonable grounds for believing that the offense has been committed. Well, they should be looking at their grounds, and first of all, they should describe the offense properly, and they should dig out all the grounds that support the commission of that offense. And then the next thing that they have to address is, will it afford evidence, which is usually the basis upon which search warrants are focused. And so they describe those things, and they should dig into their grounds and come up with credible grounds to demonstrate that those things exist. But they have to be qualified to be seized, because the only things that you can get is those things which will afford evidence of that offense. And so these things have to be linked together in the grounds. And then going on, there has to be grounds that some part of these things are in a building receptacle or place. And so the ITO should describe that place. The grounds should be dug up to demonstrate that that place exists, but the grounds should also demonstrate that those things are at that place. So these things are all interrelated together, and the grounds of the warrant or the ITO should put this all into perspective based on the descriptions, the grounds, and how they link together. When you're looking at ITOs, there are some common deficiencies that you should watch out for. First of all is unsourced narrative grounds. And when it comes to an ITO, you're not allowed to have supporting grounds that are simply narrative. You can't just say, so-and-so killed so-and-so. You can't, a pure narrative ground may as well not have been there because it has no basis in fact. So you're looking for grounds, and we still see them quite often where they simply say things in the narrative, and that you can see that often in introductions or overviews in ITOs where there's this unsourced material, and it's perfectly fine there, but sometimes the writer will forget that saying it there is not good enough. You have to go on and create grounds which demonstrate those unsourced things actually happened and actually are likely so. So you can often discount anything that appears to be purely unsourced narrative when it comes to the actual grounds. Often things to worry about are poorly introduced confidential informants, not properly introduced into the scenario in terms of both of who they are and some kind of nondescript name or identifier, and that usually flows into a poorly qualified informant in the sense of have the police demonstrated that this person is likely a person who gives credible evidence, even though we can't give the court the context of who they actually are and how they fit into this particular investigation. Often you're looking for uncorroborated informant information. If there's nothing to corroborate that stuff, sometimes it's corroborated by other informants who are different. Look for some statement that when they're using multiple informants, they're different people, or the officer doesn't know where they're different people, one or the other. Because if you can't use you can't pretend there are two informants when there's only one, and you've got to watch for that potentially. Also, sometimes you'll see offenses in the description which are not mentioned in the grounds. So they've listed a whole pile of different offenses that appear to have been committed, but when they got into the grounds, we see no credible material that shows those offenses probably happened. Again, seizable things, look for seizable things in the description, again, that are not mentioned in the grounds. Sometimes a good thing to do if you can OCR the ITO, you can actually search for things. You can look in the warrant and say, okay, they have asked to seize, a bloody knife or something like that. And you can do a search and say, is there a knife referred to in the ITO? And strangely, every once in a while, you'll find there are things in these descriptions that have no appearance whatever in the ITO. And if those were the things that were seized, now we've got a potential problem. So you want to do certainly a quick look as have they actually got some grounds that deal with that particular thing they're looking for. In the drug world and certainly in the criminal code world even, it's not uncommon for there to be kind of a standard description of stuff in a particular case that is, passed on from officer to officer or used in a template. And very often, sometimes it's not read and the grounds don't address it. And so those things become, even though they might be found and seized, the warrant will not be held to authorize their seizure. Sometimes there are place descriptions not mentioned in the grounds. Again, they want to search a particular address, and if you do a quick search of the ITO and the address isn't there, you got a problem, right away. Recency is very, very important when you're dealing with movable things, okay? It's one thing to say the stolen car might be in somebody's garage, but what about a bag of drugs 6 weeks ago? Not likely. So when they are swearing an ITO, they're saying, I have reason else to believe these things are in that place now. That doesn't mean they will be there when you get there, but you have to have grounds to believe they're there now. And so recency is critical. Sometimes we have lots of stuff that is historic in terms of prior investigations and prior things that people have seen about particular situations, but you got to watch that there's something current, something relatively recent that points to the belief, reasonable belief that the things are there now. Watch out for unqualified opinions from the informant or other people. Cases have been gone into the ground where people who were not properly qualified in the ITO to give an opinion give one, and that's something that has to be watched for, because the average person, as a matter of law, can estimate speed, height, distance, sobriety, those kinds of things. The court won't stop that. But if the officer purports to have some kind of special training or experience and gives an opinion on that, that can be a problem for the underpinning of the grounds in the ITO. Also watch for unsupported beliefs. It's not unusual to see, and I've seen many times, the phrase, it is believed that so-and-so is a criminal or whatever, okay? And the minute you see that, you realize that that's probably not going to be of any value. What it signals to the reader is the writer didn't believe it or couldn't say they believed it. They couldn't find anybody else to believe it, but they hoped the judge would believe it. So watch out for those things, and you can totally discount those kind of unsupported beliefs in such documents. Again, something to watch for, as I said, the pure narrative is not permitted. The grounds in your ITO have to be sourced. If you're saying something is fact in the ITO, somewhere on that paper, there must be a source of where did it come from in this investigation. You can't just give conclusions or opinions or facts without telling the court where it comes from, because the court can't assess its credibility or reliability unless they can assess, well, where does this come from? How does this fit into this investigation? The case I referred to, Justice Hill's case in Ontario, is an interesting case to read because it's a wiretap case where Justice Hill went through, I think he said he read it 10 times. He picked out every grammatical and spelling error. At the end of the day, denied the application, not because the grounds weren't there, but because he essentially couldn't figure it out. It was such a mess. Okay, so you got to look at how well are these things written, and are these particular grounds sourced? And I say that factual sources for grounds have to come from one of these things, okay? They have to come from the officer, the particular affiant, for instance, their own personal observation or things they did. What did they see? What did they do? They also have to come from, often from seized documents or other exhibits or forensic, maybe forensic results, scientific analysis. And then everything else comes from third parties, which is often the colleagues, the other investigators, witnesses, agents, confidential informants. And again, when a source is somebody else than you have to explain how that person knows, and the grounds have to demonstrate that so that it's a credible source document. And my submission to the police when I do training on search warrants is, if you can't fit your ground, your wording of your ground sourced to one of these places, you probably haven't sourced it. Okay, so look for the sourcing of the particular grounds. Clearly, unsourced grounds can't be relied on to support the warrant. For instance, if you have the clause I put up here, 10 people went to somebody's house, and somebody saw 10 people go, or actually I shouldn't say that. 10 people went to so-and-so's house and each stayed the house between 1 and 5 minutes, okay? Now, that is valueless essentially because there's no source for that. A properly sourced ground should look something like, on this date, this officer did some surveillance on the suspect's house, and according to the report which the officer read, blah, 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 these are the things that they saw. That is a sourced ground. The one on top is not. So watch for these kinds of things. Again, grounds have to be sufficient. The ITO has to have at least one or more source grounds that create a reasonable belief that each offense listed in the warrant and the beginning of the ITO actually happened. And again, when I say each offense, that doesn't mean that if you have two or three offenses and one is not properly sourced, the court will ignore that one. That one will disappear, and so long as the seized evidence still fits the other offense, it's probably not going to be a problem. You might waste some time arguing. Also, each thing listed in the warrant and the beginning of the ITO qualifies to be seized. For example, will afford evidence of the offense. If that's the allegation, then each one of those things listed has to fit that category, and the grounds have to demonstrate that it fits that category. And again, each place listed in the warrant and the beginning of the ITO also has some of the things seized. So again, this is what you're looking for in your grounds sufficiency. Focus on the thing seized, because your assessment needs to address whether the thing seized, whether the thing or things seized are needed to prove some element of the charge and are likely what the accused will want to exclude. Were those things lawfully seized under the warrant authority, meaning that the thing or things fit within the things description in the warrant, are qualified to be seized by factual information in one or more source grounds. When the ITO was sworn, afford evidence is the classic one. Where were they likely to be present at the place based on the factual information in one or more of the sourced grounds? That's where your focus is, because if there's nothing that was seized that matters, you don't care if it's a good warrant or a bad one. One of the warrants that often cause a lot of trouble are the mobile phone data warrants, the cell phone warrants. And certainly in the drug world, they can often make or break the case, particularly when you're dealing with trafficking or for the purpose of trafficking. And common things to watch for are insufficient source grounds to support, inefficient source grounds to support the description of the phone in the warrant. More than once I've seen this problem. For instance, you will see in a warrant, the phone is described with its make or model and a police assigned exhibit number, but there's not a word in the grounds to show such a number was assigned to the seized phone. And sometimes we have to hang our hat on it's the same color that they say it was, okay? So you want to make sure, one of the first things I look for is, okay, how do they describe the phone? Does that description fit with the description of that item in the ITO? And very often it does not, and you may have potential problems there. Problems with describing the phone make or model and their IMEI number or something like that, but there aren't any grounds to link that number to the seized phone, sometimes not even mentioned, as I said. Often you have to worry about insufficient source grounds to support that there's likely data in that phone that will afford evidence of the listed offense. It's very common to have grounds explaining the officer's belief in the likely presence of incriminating data in a drug dealer's phone, for instance, based on training experience, often or sometimes without details of that training experience. But failing to link that likelihood to the phone actually seized. There's no mention, even though it's in the report someplace, there's sometimes no mention of the fact that the person was during surveillance seen using it, looking at it during surveillance of drug transactions, or for instance, it was constantly ringing or text messaging pop up from the point of seizure on. And that to me, that is evidence that should always appear in the ITO and a phone warrant if that evidence exists. And it always amazes me that it often doesn't get in there, even though they have lots of that evidence. So watch that, because it's not just that that drug dealers' phones will likely have incriminating evidence. Okay, why is it that this particular phone, there's some basis to reason it's going to have some kind of incriminating evidence. Confidential informants are things to really be careful about when it comes to ITOs. We all know that they're often the bread and butter of criminal investigations, the key evidence that links to the accused of the crime very often. And although confidential informants will not testify or give evidence, their information is often the key to getting the warrant to capture that critical evidence. And same situation applies in drug investigations. So if their information is needed in the ITO, and hopefully they don't use them if they aren't needed, they must be properly introduced, they must be properly qualified, and their information must meet the 3 C's of DeBow. It has to be compelling, credible, and corroborated. And for the ITO writer, it is a tightrope walk. And the art is to be able to use as much of the confidential information as is needed without breaching informant privilege. And again, by writing about the information they gave without having those words risk identify them. And it's very difficult to do well and very easy to make mistakes. And so as soon as you see an ITO with confidential informants, again, your antenna should go up and you want to scrutinize this very closely as to how you're going to deal with these particular problems. And sometimes the fact that the informant writing was not done well might end up putting the Crown's case in great jeopardy. Introducing the informant, again, it's critical how many informants are being used, what's their background, how do they fit into this game in a generic way, how does that information, like is it personal knowledge or third-hand hearsay that they've gathered somehow? How does this information, or how is this information, identifying information, going to be provided to the justice, how it's dealt with? For instance, if they're using attachments and things like that, like in a confidential exhibit where a detail is included, you may not see that right off in any event. This is just a long-winded example, and you can look at it later if you like sometime, but this is the kind of thing that we expect to see in introducing a confidential informant in a particular ITO, describing how they know things, what you've done to dumb down the information, and those kinds of things, what can't be disclosed, and things that you want the judge to know about where they are that only the judge or justice will be able to see. Qualifying them, again, needs to be, they have to meet those 3 C's of DeBow, which is compelling, qualified, and corroborate, or compelling, credible, compelling, and corroborated. And there should be individual separately headed qualifying paragraphs for each informant, which generally describes, gives them a non-identifying description. How's their past performance been? Have they given investigation or information on this investigation as past ones? Have there been good results? Is there a motive, either pure or not pure? I really get tired of seeing judicial consideration, which is nonsense. But really, it means I want to get out on bail or want charges not to be laid or whatever. But they have to be careful as to how they identify the motivation that may be with this particular informant. How are they connected to this kind of offense? Are they in the milieu of criminals and would be people who would know these kinds of things? Do they have a criminal record or not? So just to very quickly summarize and wrap up, when you're assessing the warrant, is there a statutory provision that authorizes it? Is the offense listed? Does it qualify under the statutory provisions authorizing the warrant? Is it properly worded? Are the things to be searched for, do they qualify under the statutory provision authorizing the warrant? Are they properly described either as a particular thing or a limited class? Is the place to be searched one that qualifies under the statutory provision? Is it properly worded, describing a specific place and in some cases a thing, a receptacle? And does it give a date and time when the entry can take place? Is it signed and dated by the judicial authority permitted to issue it under the statutory provision authorizing the warrant? If you're assessing the ITO, again, summarizing, look for and exclude or at least discount unsourced narrative grounds, poorly introduced confidential informant information, poorly qualified informants, uncorroborated informant information, offenses described not mentioned in the grounds, seizable things not mentioned in the grounds, places in the things not mentioned in the grounds, unqualified opinions, unsupported belief, and then you assess what remains, and is there a credible, factual, sourced ground supporting a reasonable belief that the specified offense is probably committed. Similarly, are those kinds of grounds reasonable to believe that each of the things seized will probably afford evidence or otherwise qualify? And are there the same kind of grounds to justify a reasonable belief that the things to be seized are probably in the place to be searched? I think I've met my time requirements. Where do I go from here? Neil.
Thanks, Eric. That was excellent. We do have a couple questions from Darcy Kachuk, and the first one's the easy one. Please advise whether slides will be made available to attendees. I know that Daniel has already answered this. Eric, will you be providing your slides to participants?
I will provide them to the Law Society and they can distribute them.
Perfect. The second question is, to help address recency, can a conditional warrant be issued? I.e., if a police officer observes X, they may search.
I don't think so. I think that's a terrible risk because essentially the argument's going to be the court has now delegated its authority to the police officer, which, it's just not permitted to do that kind of thing. What sometimes happens, though, is that you may well not have enough of a grounds for a particular warrant or seize a particular thing, but there are other powers that are available to you sometimes in the right circumstances. If you're lawfully in the right place, you can do certain things that you don't need a warrant for. But again, that's beyond my presentation. But I don't think a conditional warrant is a good idea and should never be done, in my opinion, because it's subject to the unlawful delegation argument, which would probably win.
Yeah, I think that'd be tantamount to an anticipatory warrant, which isn't allowed.
I think it's different than, and then that's, again, anticipatory or in the general warrant situation where you actually can do stuff like that, okay? If you can meet the requirements, but in a straight out, you can go this place and seize this thing, I don't think that could be conditional. If you find it, you can seize it. No, I don't think that would be allowed. Somebody's tried it, I'd love to know.
Fair enough. Did we have any other questions from the members? Okay, I'm not seeing any. I'm wondering, we've been going for about an hour and a half. Daniel, what are your thoughts on 5-minute break starting at 10:30?
Yeah, I think that's a health break would be good.
Okay. All right, everyone. We'll be back at 10:30, and Daniel's already got his PowerPoint up and running, so I'll just properly introduce him for everybody. Daniel Song practices as counsel to Pringle Law. He manages the Vancouver office and practices criminal law in Alberta and British Columbia. He obtained his law degree from the University of British Columbia in 2006. Daniel has broad trial experience defending clients faced with serious and complex charges. He has also extensive experience as criminal appellate counsel, having represented clients at the Supreme Court of Canada in more than 20 cases. He's also an adjunct professor at UBC's Peter A. Allard School of Law, teaching legal rights under the Charter. He's also an advocacy advisor for the Supreme Court Advocacy Institute. a board director of the BC Civil Liberties Association, a member of the Legal Aid of Alberta Appeals Committee, and a supervising lawyer for the UBC Innocence Project. Daniel was appointed King's Counsel in 2022. Daniel, I will leave it to you, and I'm here for any help you might need. Thank you.
All right, thanks, Neil. I would invite everybody to, if a question just pops up, I have the question and answer box on my screen, and so I'll try to interact and answer questions as I'm going. So feel free to ask those questions during the presentation. I'm going to give a perspective about challenging search warrants from the perspective of defense counsel. I want to stress some of the issues that can arise in terms of challenging search warrants that surround the actual ITO. I'll go into a little bit about the Garofoli review as well, but I am going to spend some time with some of the issues that many of you will also need to be mindful of as you think about how to challenge search warrants and other issues that surround those warrants. And so, as I'm trying to use this PowerPoint, the first thing I'll discuss is the application for summary dismissal that could occur if, as defense counsel, you intend to challenge a search warrant or any of the searches that occurred prior to the warrant. The second thing I'll deal with is standing itself, whether your client has the ability to challenge that warrant or challenge any of the searches that the police had undertaken in the investigation. And of course, all of you know that hinges in the Section 8 context on establishing an expectation of privacy. The third thing I'll review is the Garofoli voir dire, and what I say is probably the most significant aspect of it from the point of view of the defense, which is the application to excise portions of the ITO. And then I'll speak briefly about the continued detention of seizures after the police execute a warrant and hold on to items. And then I'll touch on a couple of issues that arise in the search warrant context under 24.2 that's specific to the Section 8 challenges arising out of Garofoli. And so before you challenge a warrant, you do want to consider whether you can establish standing and resist a habisher application, the application to summarily dismiss your application. Now, many of you, maybe, I know Yukon Law Society and the Yukon Bar is, of course, a separate bar, but you will appear in front of many of the appellate judges, of course, who sit in British Columbia. And you may be aware of how, particularly in British Columbia, there was a penchant for Crown to, over time, bring a lot of vucalage applications to summarily dismiss charter applications and arguments that the defense intended to bring in a case. And that case, of course, the issue of the standard for summary dismissal went to the Supreme Court of Canada in Habisher, and I'll go through that in a couple of minutes. But the other thing that you want to be mindful of in this day and age, challenging search warrants, is how the issue of privacy and establishing standing, particularly when it comes to digital privacy and electronic communications, are constantly in flux. So you need to be mindful and pay attention to the Supreme Court of Canada cases, of course, but also the appellate cases across the country, which you will find when it comes to a contentious issue regarding privacy, will often be conflicting. And so it does two things. I mean, it creates a little bit of uncertainty in terms of how to advise your client as to whether there is a meritorious argument to be made on behalf of your client in challenging a warrant or any other searches. And at the same time, it offers fertile ground for defense counsel to be creative about how to advance arguments to establish an expectation of privacy, which I'll also highlight a little later on a different case. And so the threshold for summary dismissal was decided by the Supreme Court of Canada unanimously in Havishar. I was one of the counsel who represented Mr. Johnston, who is co-accused. Many of you, if you've been around long enough, remember the Series 6 case, which I want to say I think the homicides in the Series 6 case occurred in around 2007 or 2008. And that litigation is still ongoing. It's an incredibly unusual case with an incredible history. It involved the notorious Bacon brothers and the Red Scorpions having a dispute with other individuals who were alleged to be involved in the drug trade in the Lower Mainland. And it culminated in a conspiracy and plan to kill one individual who Jamie Bacon was alleged to have tried to extort with respect to a so-called tax for running a drug line on their turf. And because that individual didn't pay, there was this plan to kill that individual. When individuals appeared in the Surrey apartment where that individual was believed to be, there were other individuals who were there, 4 individuals, including I think 5 individuals, including a technician for the fireplace. And then, of course, as many of you have read, there was also a young boy who was walking down the hallway who was pulled in just because the accused were alleged to have believed he might be a witness, and all 6 were executed while they were on the floor. The reason this case has taken such a circuitous route to where it is today is because of some of the things that occurred with respect to state conduct. The police that were involved were alleged by the accused to have conducted some extraordinarily unusual tactics to ensure that witnesses would cooperate, including having sexual relations with key witnesses. Officer Brassington, whose case also went to the Supreme Court of Canada, was ultimately convicted after a guilty plea after he lost his case in the Supreme Court of Canada for breach of trust and other offenses. And the police were also alleged to have directed corrections to put the accused in this case in what was akin to torturous confinement, 24 hours of lights, single cell, solitary confinement, feces and blood on the cells. And so because of the officer's conduct with respect to the witnesses and the police directing CSC to effectively inflict cruel and unusual punishment on the accused, there was an application at trial to for a stay of proceedings based on abuse of process. And while Justice Wedge, who was the trial judge, concluded that there was merit to the abuse of process application and held that there was reasonable prospect of success in establishing that, held that there was no prospect of success for a stay of proceedings in a case like this. And so when the case went to the BC Court of Appeal, there were a number of issues raised by the appellants, but the BC Court of Appeal allowed the appeal in part, dismissed the conviction appeals, but allowed the appeal because in the court's view, Justice Wedge prematurely dismissed the application. The Crown applied for leave to appeal to the Supreme Court of Canada. Now, if the Crown had not done so, we may still have bucalage. But after the Crown obtained leave, at least our team for Team Johnston, we felt that it was an opportune time to try and advance an argument about the correct standard for summary dismissal. Bucalage has been around for decades, and the Supreme Court of Canada had never commented on it directly, or at least considered the issue. There were some tangential comments in Cody and I think in Jordan as well. The unusual part of the case was that the defense had at the BC Court of Appeal conceded that the threshold was whether the application had a reasonable prospect of success. But at the Supreme Court of Canada, we took a little bit of a braver tact and asked the court to hold that the standard should be frivolous, tantamount to when an appeal might be struck, and a notice of appeal might be struck because it discloses no real appeal, or where you obtain bail pending appeal with respect to the first stage of the test as to whether the appeal is frivolous. The Supreme Court of Canada, through Justice Martin, agreed that there was an issue with the inconsistent application of vukolich and the proliferation of the summary dismissal applications, which sometimes took longer than the voir dire itself. And so the Supreme Court of Canada held that the standard for summary dismissal is not just frivolous, but manifestly frivolous. And so she says that the standard draws on a case law for frivolous applications, but she says that it also requires that the flaws in the application are manifestly apparent. And she says that she added the word manifestly to capture the idea that the frivolous nature of the application should be obvious. And it connotes the necessity of failure. And so as Crown Counsel, there may be a view that now a vukolich application, now a Havishar application, might not be as successful as it once was. But I think that's the right thing to do. However, as defense counsel, you still have to ensure that the applications you bring and a challenge to a search warrant, for example, is going to be founded in some way or founded on a proper basis to say that either the warrant will be set aside. I don't think there needs to be an issue about 24-2 and trying to establish if or how the evidence might be excluded. But in terms of establishing a breach, you have to show a pathway. And so the key takeaways from Havishar are that the screening function, this also equally applies to Crown applications. So defense counsel should be aware that if there's a Crown application being made in a trial, it doesn't have to be a charter voir dire. It's open for defense to bring that application as well. The burden rests on the party seeking summary dismissal. The frivolous nature of the application should be obvious on the face of the record, and the manifestly frivolous standard does a couple of things. It protects the fair trial rights and ensures that applications, including novel ones, should be heard on the merits. And the key thing about, and one of the issues that occurred in Havishar at the BC Court of Appeal and what was contentious is whether the trial judge could engage in limited weighing and draw their own inferences when there are competing inferences, choosing which inferences to draw from the facts as they're taken at their highest, which is what a judge hearing an application like this is supposed to assume. And the Supreme Court of Canada said, no, you don't do any kind of limited weighing as a trial judge. You draw the inferences that the accused is seeking of, and asking the court to draw, as long as it's logical, of course, and then decide whether the application is manifestly frivolous. So after Havishar, there were a couple of cases in which the courts have applied the new standard, and one of them was Havishar. And so right now, that case, as I said, is still ongoing. Mr. Johnston, our client, had passed away about a month before the Supreme Court of Canada released the decision. So his case, of course, is no longer proceeding. But Mr. Havishar's case is ongoing. Mr. Havishar tried to broaden the abuse of process motion itself after the Supreme Court of Canada appeal, and the Crown sought summary dismissal on a portion of that application and motion, and Justice Devlin dismissed it. So it was a valiant effort to try and get Havishar, but at least at this point, they weren't successful. There's a case called Carnegie from the Court of Appeal, in which the Court of Appeal overturned the trial judge's decision to summarily dismiss a Section 9 argument. That's partly because the capture hadn't been released and the judge had applied sort of the old higher threshold of no reasonable chance of success. And that is now going to be heard at the Supreme Court of Canada. Unlikely the issue of summarily dismissing the application, but on the interpretation of Section 495 and the necessity for the arrest. So be mindful of summary dismissal. Just because the threshold is now more onerous for an applicant to try to have something summarily dismissed, doesn't mean that it won't happen to you as defense counsel. So it's important to frame your arguments in a way that demonstrates that you're not wasting the court's time. So moving on to standing and privacy. Now, many of you know there are a line of cases that define sort of three general areas of privacy, though they're not hermetically sealed categories: personal privacy, territorial privacy, and informational privacy. Often, and when you are advancing a claim for reasonable expectation of privacy, it may overlap with one, two, or sorry, a couple of these categories, or even all three. But in arguing whether there's a reasonable expectation of privacy, the important analytical fact is that we apply the normative approach. And what is that? It's asking in the analysis broader questions about what society expects to protect, and what in terms of what society expects we wish to have private and maintained private and away from state eyes. And so the analysis is normative, not descriptive in the sense that it describes the specific case that is before you with the area that might have been breached by the police, which might have contained illegal activity. And the assessment, of course, is content neutral. The illegality of whatever you're dealing with in a case is not to be considered. And so the question really is, what are the what should we expect in terms of privacy in relation to whatever you're claiming? One of the questions that's helpful, but it's not and should not be taken as the determinative question, is what are the police really after? And the reason I say it shouldn't be determinative is because if you continue to ask that question, what are the police really after, you could develop a line of argument that almost always will result in you saying there should be an expectation of privacy, because the police, of course, are always going to be after a lot of the times information that you do want to keep private, but the target information, or at least the area in which they enter the sphere of what you say should remain private, is what needs to be you need to focus on, rather than always directing your focus on the end game in terms of what the police were really looking for. And in order to do that, you ask a different question, which is whether there's a potential for that thing to reveal personal or biographical core information. So how does that work? So the totality of circumstances framework requires you to, and this comes from the Edwards case, where you'll see a whole list of factors that the Supreme Court of Canada had listed, but these four sort of headings encapsulate those factors in a broader way, because of course those factors are, as we all like to say, non-exhaustive. And so you have to situate the subject matter of the search and describe that and define that subject matter, and that the way you define it often will drive the analysis, as we'll see later here when we look at bifurcates. You have to establish that the claimant had a direct interest. That's usually pretty easy, as is the subjective expectation of privacy. Don't necessarily need to advance evidence these days, particularly given the Supreme Court of Canada's decision in Jones, and where the majority of the analysis often happens is this fourth stage as to whether the subjective expectation is reasonable. And so not sure, Neil, if we can try this. I've never done this on my own. I usually have some help in terms of doing the poll question, but I'm just going to ask all of us to go through this question and see if, and all of them, you can flip a coin if you don't know, because there'll only be two answers. But a group of accused had possession and control over a leased residential property for approximately 1 month. To obtain the property, they fraudulently used an intermediary who they paid to ensure that their names were not connected to the property. The accused used the property for a month prior to the date when a warrant was executed on the property. The property was converted for use as a meth lab. The appellants had the practical and physical ability to regulate access to the property in the sense of admitting and or excluding others. So did the accused have standing to contest the warrant? In other words, did the accused have a reasonable expectation of privacy? So we'll just wait a couple of minutes to see what all of you say.
And are you able to see the results of the poll?
I don't know.
I've got it up and the answers are trickling in.
You may have to assist me and just let me know. Yeah, I don't see it, but
No worries. They're all together, so I'll just read what we have. It looks like 11 say yes and 3 say no.
the answer, at least to the Ontario Court of Appeal, is no. And those who said yes, don't worry. I mean, I'm not sure I agree with the Ontario Court of Appeal here, but the Ontario Court of Appeal held that there was no standing in these circumstances because the accused's possession and control were undermined by the fraudulent way in which the house was obtained, and that the use, that while they could physically admit and exclude others, had no, they didn't have a legal right to do so. So my question is, in this case, whether that really was a content neutral and normative analysis. The trial judge had conducted an analysis applying the Edwards factors in sort of a mechanical and strict way. And the Ontario Court of Appeal upheld that. I mean, in part, it might be, I mean, the Ontario Court of Appeal might have just agreed with the overall balancing of the factors, but ultimately, the conclusion that the Ontario Court of Appeal reached in this case, I do question whether focusing on the fraudulent way in which the house was obtained and used really is a content neutral way of saying that there's no expectation of privacy when they were still using the house in a way that one might expect, other than using it for a meth lab, in terms of being able to be there and regulate access. And so the area that I previously alluded to with respect to digital privacy is, as I said, an area that constantly changes. So Bykowicz's case from the Alberta Court of Appeal as of right to the Supreme Court regarding what appears to be a simple question about whether there's an expectation of privacy in IP addresses. And many of you may know that in Spencer, the Supreme Court of Canada said that the subscriber information, that is, the name and address and that the subscriber will hold that's connected to an IP address attracts a reasonable expectation of privacy. And so after Spencer, if the police have an IP address and they want to get the subscriber information, they need to have reasonable grounds to believe that there would be evidence afforded of an offense by doing so. But this question in this case was whether the IP address itself attracts a reasonable expectation of privacy. And so in this case, the police were investigating online credit card fraud at a liquor store, and they contacted the credit card service provider, Moneris, and asked for IP addresses connected to those purchases. So the police just picked up a phone and asked Moneris to hand over the IP address, which they did. And the police used that IP address to obtain a Spencer warrant, got the subscriber information, was able to determine who that individual was, and then ultimately was able to effect an arrest and charge Mr. Bykowicz. The application of the normative approach in this case is very important for, I think, for all of us to read, because you'll see how difficult it is and why it resulted in a 5-4 decision. And this 5-4 decision wasn't what it was supposed to be, because when we were before the Supreme Court on this, it was only 7 judges who were sitting. It was in January of last year, and it might have been the last criminal case that the Supreme Court heard before Justice Brown was put on leave. And once Justice Brown was placed on leave, we didn't hear back from the Supreme Court of Canada until September of 2023. And the court did something very unusual. They said they were going to do a rehearing on the case with a full bench, Justice Morrow now having been brought in, having all 9 sit, watch the webcast, and if they had any questions, they were going to send it up to the parties. Now, they didn't send any questions, and what happened after is the majority finding that an IP address is a first digital breadcrumb that might betray personal information, cataloged by third-party companies, and a dissent saying that IP address is essentially meaningless. That, in my opinion, may not have happened if Justice Brown had not been put on leave, because during the hearing, he appeared, it seemed that he was opposed to the idea that the normative approach would take it to the level where an IP address would attract a reasonable expectation of privacy. But as it occurred, we had Justice Karakatsanis, who for the majority, applying the normative approach, said that the IP address and the specific online activity that it might be associated with would tend to reveal that highly private information. She focused on the fact that when you correlate that IP address with the information that might be volunteered by private companies and collected by the state, that the IP address can reveal a range of highly personal online activity. So very much is tantamount to as if the IP address is a key to unlock all the activity that we might all, and traces of activity we leave behind on the internet, which in isolation wouldn't really say very much, but the IP address would be able to tie that all together. Justice Cote for the minority said that in this case, that the IP addresses were not private and did not, and this is what was key and what was the difference between the minority and majority. She focused in on the facts in this case. That's where it becomes difficult, because a normative approach to the privacy, while of course we'll deal with the evidence that might be in a case, because it's normative, it's not necessarily going to be tied closely to the facts of a case. And in fact, sometimes I would say that an overly focused approach to examining the facts and assessing expectation of privacy can lead a court to stray away from the requirement that the analysis be content neutral. So she, on behalf of the minority, held that the expert evidence here said that the IP address would only really have any meaning if it's combined with that other information and tend to reveal intimate information about a person. But she says that nothing in the evidence suggests the police can obtain any private information about an individual with an IP address alone. And so it's true in this case, in Bajkovic, there was no evidence that the police went out and asked Google or Facebook or anybody else to give them information to connect an IP address to various traces on the internet. But there was expert evidence that did talk about how that's possible. It's something that can easily occur if the police have that information. So, as I said, normative approach is not a simple framework to apply, and so it provides defense counsel with opportunities to raise issues and creative arguments, but it does still sometimes lead to a little bit of uncertainty as to where the boundaries of privacy might be. And so one of the questions that arises, and I think an important question that arises after Bajkovic, is whether there's a reasonable expectation of privacy in an IP address if that third-party company volunteers that address to the police. So, and I say that that question is likely lingers from Morocco, where the Supreme Court of Canada said, if you send a text message to someone else, that person who holding that phone, you still have an expectation of privacy in your messages in that phone. They didn't deal with the question of whether that person who's on the receiving end just goes to the police and say, hey, I've got all these messages that say, all these things that might be relevant to a criminal offense. One of the things that happens right now is that the U.S. National Center for Missing and Exploited Children can choose to take the information that they have in relation to an IP address and forward it to the RCMP and say it's connected to the transmission of child pornography. And so the question is, can the RCMP use that IP address to obtain a Spencer warrant? And so the Supreme Court hasn't squarely decided that, and whether that third party volunteering private information in their possession engages Section 8. I would say that it's not onerous for the police to take the information that they receive from an entity like the NCMEC and take it and put it in grounds for in a simple production order, apply for a production order, and then obtain the IP address after receiving that information. But as it stands, it doesn't seem like they had decided, but maybe they have. So the second question I'd ask is for you to consider this scenario. So police enter a private residence with the consent of an occupant in the aftermath of a domestic assault. The woman they spoke to advised the police that her common-law husband, who was responsible for the assault, had also been in possession of child pornography, which he kept on the home computer. She signed a consent form allowing the police to take the computer, and the police did not initially search the contents of the computer, but approximately 4 months later, they sought and obtained a search warrant allowing them to access the data. And so in the seizure of that computer, did the police violate Section 8? So A, the police violated Section 8 because the accused maintained a privacy interest in it. The very act of taking the computer deprived the accused of control of the data. Or B, the police did not violate Section 8 because the accused's expectation of privacy was reduced, and it was reasonable for him to expect that as shared property, his spouse could turn it over to the police, and police did not search the contents of the computer until they obtained a warrant.
Submit this again. Answers are trickling in. Looks like we have 11 for B and 6 for A.
All right, so minority wins again. So this is Reeves. This is a case of Reeves that the Supreme Court of Canada decided a few years ago. And I believe it was Justice Fitch who says that he acknowledges that the police could not actually search the data until they obtained a warrant, but nevertheless, while the privacy interests engaged by a seizure may be different from those engaged by a search, Reeves' informational privacy interests in the computer data were still implicated by the seizure of the computer. So when the police seized the computer, they didn't just deprive Mr. Reeves of control over the intimate data, but they also ensured that such data was able to be preserved subject to future state inspection. And so the key thing is that even though Mr. Reeves was sharing and had a shared privacy interest in that repository, the computer, and his spouse could have access to that computer, the spouse could not waive Mr. Reeves's expectation of privacy just because she shares an interest in that computer. And so, as I said, it said here, consent of the spouse did not nullify Mr. Reeves's expectation of privacy. And so, in this case, Justice Karakatsanis says, the issue of whether Section 8 of the Charter is engaged when a private citizen offers information or an item to the police in which another person may have an expectation of privacy doesn't arise in this case. The issue of whether Section 8 is engaged when a citizen voluntarily brings an item to the police remains for another day. That's in 2018. But in 2012 in Cole, it appears that Cole actually dealt with this issue. That's where the school technician, Mr. Cole was a school teacher charged with having child pornography on his work laptop. The school technician was conducting maintenance on that computer. He found nude photos of a female student. So the school copied the files and handed over the work computer and data to the police. And Justice Fish said that Mr. Cole had an expectation of privacy of the content in the work computer, a diminished one. And the school's lawful possession of the laptop for its own administrative purposes did not permit the police to seize and search the computer for a criminal investigation. So this is a case where the school voluntarily provided the laptop they had access to, and they had every right to access. That didn't extinguish Mr. Cole's expectation of privacy, and the police still had to get a warrant. And I say that, once armed with the grounds from hearing from the school what was in that computer, they may very well have gotten a warrant without much difficulty. But it seems that Cole answered that question. But in 2017, Justice Doherty, in a case called Orlando Hasbro, said that he had considerable difficulty with the submission that Section 8 is engaged when police look at information in which an accused has a legitimate privacy interest, even if that information is brought to the police by an independent third party acting on its own initiative. And the Alberta Court of Appeal in 2021, along the same line of reasoning, where an appellant's wife had found child porn in the appellant's devices, took screenshots, saved them on a USB drive, and then took them to the police. Justice Slatter says that a member of the public who reports evidence of a crime is not purporting to waive anybody's constitutional rights or purporting to provide anybody else's consent, but is merely reporting a suspected crime. The examination of a USB flash drive by the police was not an examination of anything or place that belonged to or that was under the control of the appellant. This is an example, I say, of the Alberta Court of Appeal and of a court focusing on the question of control in line with territorial privacy, without really taking a broader approach that the normative approach requires, in the sense that control is only one factor in assessing whether someone has an expectation of privacy. And Justice Pachaco, who acknowledged Justice Doherty's comments in Orlando Hasbro more recently in 2023, noted that Justice Karakatsanis had that statement in Reeves saying that this decision had not, or this issue had not been decided yet by the Supreme Court. He concluded that Coles did decide that case and that it wasn't open to the Ontario Court of Appeal to depart from Coles. He says that it is arguable that this issue is open to the Supreme Court of Canada by way of reconsideration, but not open to this court, the Ontario Court of Appeal, since the SEC does not appear to have left this issue open in Cole. And so while a lot of commentators may say that Bykowitz has created this situation now in terms of whether the police and the uncertainty of whether the police will now need warrants to obtain IP addresses, even if a body or another person already has access to it. If the accused person can establish that the IP address, they have an expectation of privacy in the IP address in those circumstances, then Cole may very well be dispositive. It may not be correct that the Supreme Court of Canada has not dealt with the circumstance of whether a third party has, when a third party goes to the police and hands over information that an accused might otherwise have an expectation of privacy over. So no questions? Hope I'm not going too quickly. So after you get over the question of standing and hopefully not have your application summarily dismissed, you can embark on a Garofoli application. One of the key things that I say is important for defense counsel in ensuring that you can maximize your ability to question the validity of a warrant is making sure you have all the disclosure you need. And one of the most important things you have to do is ensure that you have all the source documents that the affiant relied on, that the affiant says they sourced in the factual assertions in the ITO. So Eric had talked about the need for an affiant to source all their assertions, and he was saying that you just can't put conclusory statements. You'll have to say there were certain grounds there that the police observed, but in terms of what the affiant says those grounds were, the affiant had to have looked at a document that set out those grounds. And so defense counsel's obligation is to look at the source documents to every paragraph in the ITO and assess whether it was accurately conveyed to the justice, whether there was anything that might have been exculpatory that wasn't put to the justice, anything that might be misleading. And so that's how you get into the question of what might need to be challenged in a subfacial review of the warrant. Be sure that you try to obtain the affiant's notes as well in preparing the ITO, all of the database inquiries the affiant himself might have undertaken. And if there are any materials outside of the investigative file, there may be a need to do an O'Connor application to try to obtain those. Just have a question from Leo. Would it have made any difference in Reeves if the police had asked the spouse to preserve the laptop rather than seized it? Or are those two actions the same for charter purposes? Well, if Reeves had tried to do that, it might be charged with obstruction. I'm not sure. But in terms of the expectation of privacy analysis, I don't think that would have had any impact. I think those are distinct acts for charter purposes. I mean, Erica, you can weigh in if you want. I can't see how the act of an accused to try to hide a laptop would diminish his expectation of privacy in that laptop. It was his expectation in the contents itself, and that the contents being information that would tend to reveal highly personal information, that's protected. So the decision to ask the spouse to hide or preserve the laptop, I don't think if his wife had held it until the police could get a warrant. Oh, I see. So yeah, so if the police had gotten a warrant to seize the laptop, and then on top of that get a warrant, of course, to examine the laptop, then there would have been no question as long as the warrant itself was valid. So if they had sufficient grounds to take the laptop or believe that it was offense-related property at the time, sure, they could have done that. But in Reeves, that wasn't the case, of course, because they simply asked Mr. Reeves's wife to sign a consent form and take that laptop without a warrant. So that's right, Leo. So I want to make sure I'm doing okay for time. So Eric had gone over the critical nature that confidential informants often play in search warrants. And so the advice I had given earlier about ensuring that you obtain as much disclosure as possible that's surrounding the warrant it also applies to information about confidential informants. And of course, the defense isn't going to be entitled to any information that's going to tend to reveal the identity of the warrant, the identity of the confidential informant. But if the affiant had reviewed handler notes or debriefing reports, then those are to be disclosed. Those would be part of Stinchcombe disclosure, because if the affiant had relied upon them in preparing the ITO, then that should be disclosed to the accused, properly vetted, of course, to be able to compare what was placed in the ITO and compare it to what the affiant had reviewed. But often, the affiant will be relying on the source handler themselves, communicating information to them verbally. And in so doing, there could be a question of what was actually communicated to the affiant. But if that occurs, there's no entitlement, at least on the authority of McKay, for the defense to ask for source handler notes or source debriefing reports. So one of the things that you want to look for is whether the affiant did rely on any of these types of materials. And if so, make sure that you get a copy of vetted copies of those documents. So after you've gotten all that disclosure, of course, and combed through it, the charter notice is what's going to help you ensure the quality of a charter notice is going to help ensure that you can resist any kind of Havishar application that might be on the horizon. And so it's a balancing in terms of not making a charter notice a full-blown memorandum, a big brief of law, particularly because a lot of the information might still be subject to evidence that's going to be led at the trial and voir dire. But you want to ensure that the charter notice can trace a legal pathway for you to say that the warrant should be set aside. And so if you're going to embark on a subfacial attack, I would recommend that you identify some of the paragraphs in the ITO that you say should be excised and the reasons for why they should be excised. If you're going to apply to cross-examine the affiant, that you outline some of the areas if you can. Be mindful that the Crown has, at least on the authority of this Mahmood case, the Crown can share the defense arguments that are in a charter notice with an affiant to give them notice of what's going to be litigated. So tactically, what you want to put in the ITO, you may want to ensure are things that an affiant, if the affiant is going to be cross-examined, wouldn't be able to wiggle around. And so there are some decisions that you're going to have to make strategically, but for the most part, you want to ensure that the notice is as fulsome as possible so that you can resist any kind of pushback from the Crown. Eric went over the threshold for Garifull review in terms of the threshold being whether the authorizing justice could have issued the warrant. You'll enter into a voir dire. You usually will have separate voir dires for each warrant that you challenge. And I highly recommend that you communicate with counsel ahead of time and work with Crown Counsel to ensure that these applications can proceed smoothly. A lot of times, Garifull reviews do not have to take a lot of court time. And if everybody is organized and you have copies of the warrants ready to be marked as an exhibit in the voir dire, you will want to have source documents ready to be marked as well if necessary. I often ask the Crown, if the Crown hasn't done so, to ensure the affiant is ready with an organized binder, whether they're electronic or not, of the warrant, ITO, and the source documents for all the paragraphs all the paragraphs that relied on source documents. You would usually start with a facial challenge before the subfacial challenge, but there's no requirement for that. It's just that a facial challenge usually is just a more straightforward application of taking a look at the warrant as it is and making your arguments as to whether the warrant should stand on a lot of the points that Eric had made earlier. The facial challenge being looking at the warrant without any amplification or excision, and a subfacial challenge being one where after excision and amplification, it's really what you say the ITO should have been when presented to the judge. Now, it doesn't really matter. The difference between a facial or subfacial challenge for legal purposes has no bearing on how you proceed with your charter voir dire. So don't worry about making that distinction if it sometimes feels a little confusing. Bottom line is if you're challenging the warrant either on the basis that it doesn't have grounds, or you're going to be applying to excise and review the ITO after those excisions, that's all part of the voir dire. It can happen in separate stages, or you could do that together. Eric already went through reasonable grounds and suspicion. So this, I just go over some of the principles in assessing reasonable grounds here in this slide. He also went through the 3 C's that are found in DeBow, that the confidential informant information should be compelling, credible, and corroborated. So it's an area in the Garofoli review you may wish to attack, that as disclosed in the ITO, often because the Crown and the police are concerned with informer privilege and protecting the informant's identity. Sometimes after redactions, even though maybe the information under the redactions are compelling, after redactions, there's just a skeleton of what the information was, and you can legitimately make the argument that the 3 C's wouldn't be satisfied. Excision from defense perspective, the defense perspective is all important. It's key to any subfacial attack. It's automatic. Remember, it's not a remedy under the charter. It's an automatic consequence of the police relying on unlawfully obtained evidence or information, sorry, or putting in conclusory statements with no sourcing or any foundation, any misleading statements that should either be corrected or taken out altogether. It's that exercise, which is highly fact-specific. It really is. And so I know that many of you might feel that doing a Garofoli review seems to, I mean, everybody kind of, you can read the law around it, and it can feel like you're treading on uncertain grounds. You're always going to feel like that in a lot of cases because it's really fact specific. You just have to read, as Eric said, read the warrant very carefully. What is the warrant authorizing itself? And then look at the ITO and compare it to that warrant. Then look deep into the ITO by comparing the ITO with source documents and build out your case in terms of what should be excised from that ITO. I've heard other judges openly say that the question of what should be excised is often very difficult. I wouldn't say it's discretionary because you should be able to identify what's conclusory, what's misleading, etc. But sometimes identifying what those, whether something is conclusory, whether something is misleading, can be tricky. And it really is a fact-intensive exercise. So I'd encourage all of you to feel less tepid about going in and trying to challenge a warrant on the basis that maybe you haven't done a lot of them. Every challenge that I do can sometimes feel new. So it's really looking at the facts in the case and seeing what you can identify are deficiencies. So one of the key things is to look at the ITO to see if you can attack and advance an underlying charter argument about information that the applicant relied upon that you say was obtained in violation of the charter. So I have a couple of examples here. If there are surveillance observations, but the police used warrantless surveillance devices that in areas where you have an expectation of privacy, you could very well establish that that information needs to be excised because they didn't have prior judicial authorization to get that video footage. Traffic stops are another common area where you can challenge the validity of the police information that was obtained. And so this is the last question I'm going to put to all of you. The police arrested the accused without a warrant for drug trafficking, but the arrest was based in part on evidence of identity that was later found to have been obtained in breach of the accused's Section 8 charter rights. Which answer is correct? A, the illegally gathered evidence should be excised since the state should not be entitled to rely on illegally obtained evidence as grounds to justify an arrest. Or B, the illegally gathered evidence should not be automatically excised because the story test requires analyzing grounds from the perspective of the officer and what a reasonable person in his or her shoes would have concluded at the time of the arrest.
Okay, we're getting some answers. It's looking pretty close. We have got 7 for A and 11 for B.
All right. Yeah, that's pretty close. So I'll say this. It was B for a short period of time. So in a case called Love, and this was a question that had been lingering for a long time. I was surprised when I started out in my career in terms of warrantless arrests and warrantless searches, that there had been no real discussion about whether unconstitutionally obtained grounds should also be excised like you do it from an ITO. So in a case called Love, the Alberta Court of Appeal a couple of years ago said that only unconstitutionally obtained information is automatically excised from an ITO. So they made a distinction between unconstitutionally obtained evidence and unlawfully obtained information, and said it's only that unconstitutionally obtained information that's automatically excised. And one of the examples I can give you is that unlawfully obtained information might be, for example, information in which the police obtained through entrapment, where entrapment is not a charter remedy. Entrapment is a common law. Entrapment is not a charter defense. It's a common law defense. So the question of whether entrapment, aside from the fact that it results in a stay of proceedings in any event, but whether entrapment and the police engaging in entrapment to obtain information that later results in your client's arrest might arguably, if this is correct, not be subject to automatic excision from the ITO. But what Love also said was that automatic excision did not apply to grounds for warrantless context at all. And the BC Supreme Court in 2019 in Flynn-Troy, which is that fact pattern that I just put to you in the poll, said the same thing. And the Supreme Court of Canada last year dismissed the application for leave to appeal in Love. But more recently, in Zacharias, which is an as of right case from Alberta, they specifically, the majority specifically overruled Love. And they said that you can get excision, automatic excision of unlawfully obtained evidence from reasonable grounds. So it's important that when you're looking to excise information, you can kind of go through the layers of onion, right? You're looking to excise information from the ITO because the police conducted a warrantless search or a warrantless, let's just say it's a warrantless search of a vehicle. And they also, even though they may have had a lawful arrest that resulted in that warrantless search, they may have relied on grounds for the search itself, or even maybe for the arrest that were unlawful, and that has to be excised from the grounds that were in the officer's mind. So Zacharias put that issue to bed. But what is confusing about Zacharias is they continue to use unlawfully and unconstitutional interchangeably. And so there hasn't been a clear statement after Love about whether excision is limited to unconstitutionally obtained information versus a more broader category of unlawfully obtained information. So in addition to the unlawfully obtained information, which I say all defense counsel here listening, I hope you press for that and raise that issue and try to get courts to move the law from where Love was, particularly since the reasoning in Love was rejected by Zacharias with respect to excision of unlawfully obtained information for reasonable grounds. Misleading information, so any false or misleading statements also need to be excised. There may be some statements that the Crown could apply to amplify if it was a technical issue that created the misleading picture. But of course, as many of you know from Araujo, the Crown's ability to amplify is very, very limited. We also have, sorry, it's not the right slide. Conclusory statements. As Eric said, all of the statements that an affiant makes needs to be sourced in the ITO. The judge reviewing the ITO or the justice needs to be able to look at a statement and a conclusion in the ITO and ask themselves, where in this ITO do I see the grounds that led the affiant to make this conclusion? And if there are no grounds supporting a conclusory statement, that too needs to be excised. There's no factual underpinning that that can allow the judge to assess the conclusion that that the affiant makes. Remember, the affiant is under a duty to make full, fair, and frank disclosure, which is another aspect of subfacial attacks. And that comes from the fact that this is an ex parte application. The police are just going in and saying, we want a warrant, judge. There's no accused person standing next to us and advancing their interests. And so the duty is on the officer to provide full, fair, and frank disclosure, including information that might be exculpatory or maybe detrimental to the application for a warrant. And if they don't do so, it's going to cause problems in terms of the judge who's reviewing the ITO to think that the affiant was maybe deliberately trying to mislead the issuing justice. Material omissions, as I said, is a way the defense could amplify the record. Now, this is as with trying to cross-examine the affiant, I would caution the defense counsel in the hearing the seminar today in terms of deciding when to cross-examine the affiant. Sometimes by doing so, you might end up amplifying the record in a way that negatively impacts your charter voir dire. The defense, of course, can amplify the record by including material or information that should have been included in the ITO. You can do that not necessarily by cross-examining the affiant. You can do that by looking at the source documents and presenting it to the judge and saying, see, this is information that should have been there that was exculpatory. But even though the Crown has very limited ambit to amplify an ITO, if you cross-examine the affiant and the affiant starts saying a bunch of things that supports the grounds for the issuance of the warrant that weren't contained in the ITO, you elicit that inadvertently from your cross-examination, the Crown can rely on that. So your amplification as defense counsel can go both ways. So you do need to be careful to ensure that your application to cross-examine an affiant is narrow, and in ensuring that it's narrow and at least focused, you'll also have a higher chance of getting leave, of course, to cross-examine the affiant in the Garibaldi hearing. Another issue that I'd ask you to be mindful of is the question of whether, for your client, you have the ability to rely on the charter violations of third parties that were tangentially related to the investigation, but where information was gleaned from those third parties in support of the ITO. The case law had been split more recently in BC. Cases have gone against the question of whether you can rely on third-party charter rights, often on the issue of standing, that you wouldn't be able to argue the breach of someone else's rights, given the applications of the reasonable expectation of privacy analysis. I would say this, I think that the question of standing, sometimes we forget that the wording of the charter is that anyone whose rights have been infringed is entitled to a remedy under section 24(1) and 2. So the question of anyone's rights who has been infringed, I don't know if I just said that right, that comes from section 24. So the question is, when can you seek a remedy? When do you have standing to seek a remedy? Remember what I said earlier about excision? It's not a charter remedy. And so I think that that's one of the key arguments that defense counsel can make about why they should be able to rely on charter violations that the police had committed against third parties and excise that information from the ITO. And the Crown's argument from the other side, of course, is it's going to just create prolixity in proceedings. It seems to be inconsistent with, of course, Edwards and the strong line of reasoning about standing. And you wouldn't want these Garofoli hearings to devolve into these hearings that just become really unmanageable because you start alleging breaches about all sorts of different individuals who are not connected to the case. But I say that the issue is still open. So for defense counsel who feel brave, I'd encourage you to try and advance these arguments. But because of the complexity of it, if you are relatively junior, I'd also urge you to seek some guidance from more senior counsel to ensure that you're on strong footing before you try making this difficult argument. Eric referred to the step 6 review. Now, I said earlier that sometimes if the confidential informant information is redacted a little too much, that might be harmful to the Crown's ability to uphold and to support a warrant in a Garofoli application. Step 6 is it comes from Garofoli. If you look at it, the Supreme Court of Canada had set out the steps in challenging a warrant. Step 6 is a procedure in which the Crown can say, well, we really need to rely on this redacted information. We clearly can't disclose it to defense counsel. So the Crown would apply to have the Garofoli review move into an in-camera hearing, an ex parte, where it is only the judge, the Crown, and perhaps even the affiant to take a look at the information behind the redactions. The defense can apply and should apply for a judicial summary of that information. Though I'm of the view that if you can get a judicial summary, I'm not sure why that wouldn't be included in ITO. But one of the more direct ways you can try to ensure that your client's interests are advanced in a step 6 application is to apply to have amicus curiae appear there, where they would not be taking instructions from your client. You would not have communication of the actual hearing itself, that's ex parte, but have the amicus perform a more adversarial function, which has occurred in the past. So this isn't common in the West. I have never had to do step 6. I haven't practically done it, but it has been over the last decade a little bit more common in Ontario. So you start seeing some cases, and so if you want to get a sense of it, looks like the Crown wants to do this, you'll find a lot of cases in Ontario that can help you in terms of the guidance on how to proceed with step 6. So we've got a question from an anonymous person. How do charter violations and a reasonable expectation of privacy apply to sniffer dog or other searches of luggage at the airport? Is there implied consent? No, so that you're talking about a warrantless search. So the sniffer dog searches and searches of luggage, of course, there are lines of cases like the Kang Brown case and McDonald that deal with the threshold, which is often a reasonable suspicion. So there's no implied consent. It's just because in the airport setting, for example, the airport is a place in which courts have repeatedly said you have a very low expectation of privacy in some circumstances. Not no expectation of privacy, but a low one. And the sniffer dog searches in an airport, for example, that might whether that applies in terms of a threshold is one question, but none of that is about implied consent. There's nothing that I've seen in the law that has endorsed anything called implied consent when it comes to Section 8. The consent has to be express. There's a case called Willier that goes through the things that the Crown have to demonstrate to show that an accused had consented to a violation of their expectation of privacy, which includes them being properly informed of the consequences of doing so, and having the ability to withdraw that consent. So that doesn't happen in the sniffer dog search context. The question of whether the sniffer dog or luggage search itself was permitted by the state is going to be based on the common law authority as to whether they can do so without a warrant. Sniffer dogs, as I said, there's a line of cases well established now in terms of when the police can use sniffer dogs. Searches of luggage in the airports in Canada are regulated by CATSA, but the CATSA security people at the airport are not there as agents of the police. They're there to ensure the security of the airport and the security of flying. So they don't have the power under CATSA to investigate luggage and search through luggage for the purposes of investigating criminal offenses. They often sometimes, if they have security concerns, when they look through luggage, they find something, then they'll call the RCMP or the police. But do look at the authority of airport personnel to conduct searches before you jump into when you're trying to assess whether the actions themselves are lawful. If the police, of course, direct CATSA agents to look through specific luggage, they, of course, are now acting as agents of the police and would be subject to the charter, just like the police would be. Cross-examination, as I said, I've gone through these points. Again, just be mindful that you can apply for leave, but you don't always have to. Don't feel compelled that you have to apply for leave to cross-examine the applicant. You could very well do a very strong Garofoli voir dire, simply looking at the ITO and the source documents and advancing arguments in front of the judge. So you have to think about the purpose of your cross-examination of the applicant and why you want to do that, and don't go on a fishing expedition. If you go on a fishing expedition, first of all, the Crown's going to oppose. They're going to see that your questioning is going off the rails. And the other danger, of course, is that you're going to end up amplifying the record in a way that might be detrimental to your client. Aside from all the excision and amplification, even if the warrant would still stand after excision and amplification, in most jurisdictions, there's been an acknowledgement that there's a residual discretion of the judge to invalidate a warrant. And Justice Cromwell, when he was at the Nova Scotia Court of Appeal, the Morris case is where this really comes from, where the applicant's conduct was so misleading or subversive of the prior judicial authorization process, the court can exercise that residual discretion to set it aside. So even if the warrant has withstood the Garofoli review. So every jurisdiction, I'm not sure, I feel like there might have been a case in Yukon as well, but definitely in British Columbia. British Columbia has not dealt with this issue squarely. They've had opportunities and they keep declining to the BC Court of Appeal has declined multiple times to address the issue, even though it had been argued. But some lower courts in BC have confirmed that the residual discretion exists and they had applied it to set it aside. This is an area in which you're not going to be able to establish subversiveness, really, in my view, without cross-examining the applicant. So this could be sort of a Hail Mary application that you can try to bring. If you're confident and you have a basis to say that the applicant was constructing this ITO in a way to mislead the judge intentionally. So after a warrant, of course, the police have to comply with the provisions of 489 and 490 of the code, taking information and items that they've seized to a justice to get an authorization and an order allowing for the continued detention of those items. And the BC Court of Appeal in Craig a number of years ago had confirmed that individuals can have an ongoing and continuing expectation of privacy in items that have been taken by the police. And that's why there's this regime in 490 where if no charges are laid and no proceedings are instituted, the police have to make subsequent and successive applications for detention every 3 months until a year, and then you have to go to Superior Court and go through that. Now, I know that when Matt Nathanson did the case in Gill, and it was all over the news that the judge had excluded all these messages from, or sorry, a video of a homicide that was found in a phone years and years after the homicide had occurred. And because the police had the phone for so long, but hadn't complied with the provisions of 490, excluded that evidence. But it wasn't as simple as that, right? The real problem in that case was that the police were deliberately disobeying advice that they received from the Crown. They had to comply with 490, but the IHIT, the homicide unit, deliberately chose not to do so. And so it's that aggravating factor that really pushed the scales and tipped the scales in a way where exclusion was warranted. So while you may find that there may be deficiencies in the way the police had complied with their obligations under 490, I just caution you not to think of it as the kind of argument in your case that's going to win everything, of course, under 24.2. And so it was that policy of non-compliance in Gill, where they had legal advice and received legal advice, and they continued to disobey it, that resulted in exclusion. There's a case called Teixeira from the BC Supreme Court from a couple of years ago that said that when the police copy the data that's in the phone, even if the phone is returned, that data, the digital evidence and the copies of that evidence has to also be listed in a Form 5.2 and filed and is subject to the same ongoing requirements under 490, subject to proceedings being instituted. That decision, if you try to look it up, you're not going to find it just yet because the case is still ongoing. I think it's a jury election, so you're not going to see the actual decision until that case is done. So lastly, just want to point out, got a couple of minutes left, that for the Crown in the audience, remember that even if you lose the Section 8 voir dire on a Garofoli review, and you can't amplify the ITO in that Garofoli review, you can do so at 24.2. So in 24.2 hearing, if you can have the affiant take the stand and describe the existence of a lot more that the affiant neglected to put into the ITO to establish there were proper grounds or demonstrate the good faith of the police, that will, of course, help in terms of the first stage of the grant analysis. Because, as all of you know, if there were reasonable probable grounds at the time, but it wasn't just placed in the ITO, the police didn't articulate it correctly, that could have a mitigating effect on the seriousness of the violation later in the analysis. For defense counsel, remember that even if you're unsuccessful in setting aside the warrant, but you're successful in establishing other charter breaches when you're trying to have information excised, and you were able to get that excised, you may still be able to take those charter breaches and argue that there's a bridge to the evidence to warrant a 24.2 analysis. So the Goldhart connection of obtaining evidence in a manner that violated the charter, that can still be argued with respect to charter violations that you were able to establish, but didn't result in the setting aside of the warrant. So remember that. And the case of Grant from the Supreme Court of Canada talks about that. And lastly, going back to this issue of third-party rights, cumulative breaches, of course, aggravate the seriousness under the first stage of Grant, and is supported by the BC Court of Appeals decision in Lauriente. but I would also ask you to pay attention to Chief Justice McLaughlin's decision in Morocco in the 24-2 analysis. Mr. Winchester, who was the third party, who had Mr. Morocco's text messages on his phone, and the police had taken that phone without lawful authority and looked at the messages that implicated Mr. Morocco. Even though they didn't argue, there was no argument about this issue, about whether you can argue as defense counsel violations of third-party rights. Justice McLaughlin relied on the fact that the police unlawfully searched Mr. Winchester's phone as aggravating the seriousness of the breach. So she relied on a third-party violation in her analysis in assessing whether the evidence should be excluded. So to the extent that the question of whether defense counsel can rely on third-party violations in some fashion in a Garofoli analysis or in Section 8 challenges generally, there's a valid argument still there to be made. So unless you have any other questions, it's 11:50, so it's right on time. I'm happy to field anything that I know I threw a lot out there for you, but if you have any other lingering questions, I'm happy to answer those, of course. And coming, Eric, did you disagree with anything I said?
I don't necessarily like all the things they said, but there's nothing wrong with them that I saw. And again, all of this stuff is so fact specific, it's hard to really complain until you got that fact issue that kind of fits the right or wrong circumstances.
That's right, yeah. I mean, as long as all of you have a good handle on these core principles, advancing these applications themselves are not complex from the perspective of how you go about doing it. It becomes more complex because of some of the facts that you're going to have to deal with in each of your cases. And when you have multiple warrants, it just sometimes the facts they just attract a lot of complexity.
I'm wondering about the case you mentioned with a section, or sorry, a 5.2 to be filed on the data as well. And you mentioned that it's not reported yet. Do you foresee this as something that would be upheld as it proceeds, or have we seen this adopted around the country? Is this sort of a new area that people should be aware of?
I think it's a very new area. I know the lawyers who are on that case, and they were in the BC Court of Appeal on an interlocutory appeal, which of course is not common in criminal proceedings, related to some disclosure. So it's a long way off, but I expect that if the Crown, of course, loses that case, I expect the Crown's going to for sure appeal that ruling. I'm not aware of any other decisions elsewhere, though I hadn't looked at anything after Teixeira.
In fairness, I think we, from in Saskatchewan anyway, from Crown side would oppose anything like that. I agree with that's what BC courts talk about, but we don't necessarily agree with that. I think there is actually a provincial court decision which might have gone the same way in a criminal code matter, but I don't have it to hand, but I think I heard about it. So
yeah. If you look up the Teixeira case and even try to put that citation in, there are some decisions that cite it.
okay.
So they would have had a copy of it, subject to permission from the court, of course, but not permitted to. It's not hyperlinked anywhere in CanLII, of course, because itself the reasons aren't available just yet.
Oh, interesting. Okay, did we have any other questions or parting thoughts from anyone? I'm not seeing anything. I want to just thank our two speakers again for generously donating their time. I want to thank all of our participants. I see the snow is starting, so be safe, everyone. Thanks for coming once again. Excellent. Thank you.
All right. Thanks, everybody.
Thank you very much. Thank you.